Thank you again for coming to our webinar. As I said, it's called Digital Health Data Protection Challenges in Russia. Today with you, me, Irina Shurmina, Senior Associate of IP and TMT Practice of CMS Russia.
Yeah, I will introduce myself, thank you. And my name is Vladislav Eltovskiy. I'm Associate of IP and TMT team at CMS Russia. And hello, everybody.
Yes, a little bit more about technical guidelines. If you can't hear us, please, but if you cannot hear, you will not hear what I'm saying, but I hope that whoever has this challenge is able to read this slide. The webinar will last approximately 45 minutes, and then will be a Q&A session at the end. You are on mute, but please write your questions. And if for some reason we will not be able to address your questions during the webinar, we will answer you by email, but normally in our experience we answer all the questions during the webinar. Our agenda today is pretty intense, but we hope it will be very interesting. So we'll talk about the consent for health data processing, because the consent is the main legal ground for processing health data in Russia. We'll talk about processing health data of employees, which is increasingly important now due to pandemic and its consequences. We'll talk about use of data for marketing purposes, which is always important and interesting for all the businesses. We'll tell you about the use in the sector of publicly available or not really data. We'll talk about privacy notice and privacy policy, how it works and should work in Russia. Of course, we cannot avoid talking about localization and cross-border transfer of data, which has some peculiarities in Russian legislation. We'll touch upon the personalization of data, or as it's called in the EU, for example, it's anonymization or pseudonymization of data. And we'll tell about the latest news about increased fines for data protection breaches, and as one of the reasons why it's so important to keep talking and keep thinking about data protection in Russia. So before we move to the agenda, we need to remind all of you, what are we talking about? What's the background in data protection in Russia? So first of all, we have a federal law on personal data that is in force since 2007. We are also a member of Council of Europe Convention 108+. We have our regulator, and we will mention this regulator several times during our presentation. The Russian abbreviation is quite complex. It's Roskomnadzor. We will rather call it regulator. And we also have a Ministry of Digital Development, Communications and Mass Media of the Russian Federation, who is able to issue some commentaries and clarifications that we already always welcome and always look forward to. And since we are talking about data of employees, we will of course mention labor code of Russian Federation. When we talk about Russian data protection laws, we'll of course base first of all our decisions and recommendations on the Russian law and clarifications and opinions of the regulator. But also we look really closely at GDPR and practice and clarifications that are issued in the EU, because our regulator several times explicitly mentioned that they are going to base their next steps and development of data protection laws in Russia also on the European experience, as GDPR is deemed as one of the most progressive and important legislations in the world on data protection. So don't be surprised, we'll refer to GDPR, and we will also try to give you some understanding of differences between the Russian law and GDPR in particular. And with that being said, we will start with legal grounds for processing health data. in particular, we will talk about consent, and I give the floor to Vlad.
Yep, thank you very much. So, similarly to the GDPR, under Russian law, one of the main and primary obligation of data controllers is to find some legal ground for processing of personal data. And given that health data is treated as a special category of personal data, the list of such legal grounds is pretty limited. So, for instance, one of such grounds is processing in order to provide diagnosis or medical service, but only if this service is provided by the professional, by the doctor, who is obliged to keep medical secret. In case of most of digital solutions, digital health applications and platforms, this is not the case, unfortunately. And these platforms and applications are provided by commercial entities. And in case of commercial entities, Russian law provides for the only option, for the only legal ground to rely on its written consent. The same, similarly as the GDPR, consent should be specific, so it should explicitly state for which purpose what personal data will be processed. It should be informed, so data subjects should be informed about all details of processing activities to be conducted by the data controller, and it should be freely given, meaning that consent shouldn't be conditioned on some unreasonable preferences or negative treatment of the data subject. Important peculiarity of Russian law is it's pretty conservative, we should say, but it is as it is, that the consent should be granted only for one purpose, which means that if you want to process personal data for several purposes, ideally you should collect several consents. Sometimes, in order to go around this regulation, companies trying to obtain consents where data subjects are able to put their signature in front of each purpose, meaning that the separate consent has been granted for each purpose. However, currently there is a bill on a legislative way. It is currently considered by the Russian parliament, where consents for several purposes is going to be allowed explicitly under Russian law. We evidently looking forward to this development because it will make life easier, and it will just eliminate this pretty archaic and I would say non-reasonable requirement under Russian law. And probably the most important thing about such consent to be given is that it should be written. What is meant by written consent under Russian law? So there are basically two options. It's wet signed or paper form consent, when data subject just signed a paper confirming that he or she consents to personal data processing. In case of digital businesses, especially digital health applications, of course, collecting such consents is not really a business-wise and commercially viable option. But we know the cases when, for instance, written consents were collected via post offices. So during registration process, simple registration is allowed, and only after that, data subject or user is proposed to send his written consent, and only once consent is received, health data could be processed. It is one of the options. It's very reliable. It's 100% sure because you will have a paper confirming consent, but it's not very business oriented, and it really lacks the feeling of user experience of application. Because if you will ask users to send some written documents, a lot of them could just avoid using this platform or application. So it's not very commercially wise step. So another option how to provide written consent is an electronic document signed by the digital signature. And here it's important to go into details of digital signatures regulation in Russia. So in order to keep things simple, let's just divide them to simple e-signature and qualified e-signature. Qualified e-signature is a special electronic document which is encrypted with specific tools, and this e-signature qualified one can be provided only by the company who is accredited under Russian law, which means that it's pretty complicated and separate process to obtain such qualified signature. And in practice, users who are usually like simple individuals or consumers, they don't have such signatures. So it's not really possible to communicate on the basis of this digital signature with regular consumers. And the second option is so-called simple e-signature. By simple e-signature, one of the options is when me as a user enter my login and password and enters into my account, into my personal account in the application or on the platform. This means that I have been identified by the data controller, and all documents which will be consented through my account will be deemed as signed by simple electronic signature. In order to legalize this procedure, there should be a separate agreement between me as a user and data controller or operator of the relevant platform or application. If this contract is in place and we agree that all documents signed in such a process will be legally binding between us, it should be fine. So simple consent seems to be like a relief for digital companies who need to obtain written consent. But unfortunately, if we look at this issue from purely and very, let's say, bureaucratic legal way, then we could see that the law on digital signature explicitly states that all references to digital signatures made before 2013 should be treated as a reference to qualified e-signature. The law on personal data is one falls within this rule. So effectively, this means that only qualified e-signature should be used in order to substitute paper consent. However, in practice, we know a lot of cases when companies are still using simple e-signature in order to receive consent to sign some documents. However, we cannot consider this option and this approach as 100% safe. So there is indeed a risk of the breach of the law. However, there is also no negative practice and comments from the data protection authorities stating that this approach is absolutely illegal. So it's all about finding commercially viable solution, how to receive a written consent and being compliant with the law, maybe accepting certain level of risk. So since we were talking about processing and legal grounds for processing of health data, we thought that it's also important to speak about employees' health data and peculiarities that Russian labor law contains in this respect. So first of all, the labor code allows the employer to request only health data that is necessary to assess whether employee is able to perform his or her job function. So any information that employer wishes to receive in advance, it cannot be requested. However, employees can be asked to provide this information together with the consent for its processing. So here is the important thing: if you process any health data of employees inside the organization, you should clearly separate whether it is processed for the purpose of checking whether the person fits to his or her position, and if it is something in advance to this. If it is something in advance, written consent should be required. And of course, you cannot force employees to provide this written consent. It should be absolutely voluntarily. In addition to this, labor code contains very strict rules regarding transfer of personal data to any third party. So it doesn't matter whether it's a cross-border transfer or a transfer inside Russia, any transfer to any third party requires written consent as well. Since we're speaking about health data, it would be strange not to touch upon some issues related to COVID-19 and how such issues are currently regulated in Russia and what we can expect in the future. At the moment, in practice, a lot of Russian companies check temperature of employees who goes to office or other premise of the company. And there was initially a question whether this is admissible process, whether there is a necessity to obtain any consent from the employees in order to collect such personal data. And during early stage of pandemic, Russian Data Protection Authority has explicitly clarified that employer doesn't need to collect any consents for this purpose, and simple check of the temperature is allowed under the ground that it is used in order to understand whether a person can be admitted to perform his or her job function. And also, given that there is a way further to vaccination across the globe actually, and in Russia in particular, we expect that some questions regarding whether employer is admitted to ask employees about whether they have been vaccinated or not, and whether such processing require any specific consent or anything else. So from our understanding, the general approach would be to receive consents because it directly relates to health data of employees, and in order to collect information about vaccination process among your personnel, you should collect consents as well. However, in case vaccination and the fact of being vaccinated directly associated and connected with the performance of the job function, you can avoid collecting such consents. So for instance, if job function requires some business trips, including business trips to foreign countries, we expect that at some point of time it will be pretty normal thing that only, for instance, people with vaccine passport or only vaccinated people will be allowed to travel, and therefore, in order to ensure that this process can be performed by an employee, employer should collect information about vaccination. Yep, so this is all about employees. Yes, Irina?
Yeah, thank you, Vlad. Moving forward to something more positive, than COVID, we'll talk a little bit about, oh, what's that? Okay, sorry. I don't know what's this. Okay. Yeah, so we are moving to use of personal data for marketing purposes. And we need to point out that according to the data protection legislation, as well as according to advertising law in Russia, prior consent for receiving advertising is required, especially if we are dealing with messages or emails or other ways of information that just popping up in our devices, for example, or mail boxes. This consent must relate to a specific advertiser. It's not possible to get the consent for me and all my group of companies and also all the partners that I do not list. So this is not normal already, although it used to be the case and used to be a standard practice. Let's say now we're moving away from this. Consent must be explicit and expressed. It can't be hidden in long texts, for example, of terms and conditions on the website. It should be a separate thing. And now, although we don't have this written in the law, we now have a developing court practice on this, and courts explicitly say that no, you cannot hide those provisions in bank contracts, for example, which are lengthy and people just don't care about advertising at the moment. They just sign it because they want to get a mortgage, for example. So it should be a separate consent. And what is really important, consent must be voluntary, meaning that provision of the service or any product cannot depend on consent. So human can't just reject giving consent to advertising. When I tell this to colleagues from marketing departments of our clients, they normally say, what? Now we are not able to advertise at all. We will not have any conversion. Nobody will come to us, etc., etc. This will kill our business. We say, well, there should be some other ways, you know, because otherwise this will lead to negative consequences and to fines and to prohibition of the whole advertising campaign. Now this is the reality. And now what is also very important is that predict check boxes are out of date. As you can see, this is the example from in vitro. It's a lab conducting some analysis and tests. This is their web page, and we just checked just out of the blue, and we saw that they also have this separate consent form. The first consent is accept personal agreement, which is actually the privacy policy. There is subscription to newsletter, and there is accepting the user agreement terms and conditions. So this is the best practice right now, where you have those separate tick boxes, and I mean, you can combine user agreement and privacy policy. This is fine, but the subscription to advertising on newsletters should be done separately. And also, we got a new provision in our legislation, in the law of personal data, saying that the silence or inaction of the personal data subject under no circumstances can be considered consent. And then it relates to processing personal data permitted for dissemination. We'll talk about this just in a second. But we got this provision. Yes, it relates to only one type of processing, which is a bit weird, but it's a question of legal technique. But finally, we got this provision, and it reflects the actual intent and approach of our legislator and of our regulator towards consents, meaning that there should be a specific action of the data subject who should give the consent. It cannot be just somewhere else. And we believe that this approach will be just strengthened, so this should be really taken into account. Moving forward to publicly available or unavailable data, we need to tell you about this because we know that many businesses rely on publicly available data that is published anywhere on the internet, like social networks or websites, anything. So we used to have this category of data named publicly available data. We don't have it anymore. As of 1st of March 2021, just recent news. Now we have the category named personal data permitted for dissemination. So as of 1st of March, we have new rules for publishing data somewhere on the internet, for example, and using data that is on the internet. And these rules are pretty, let's say, unusual. We were trying to find some similar rules in other jurisdictions. We couldn't find those. So this should be taken into account, that this is a specific thing for Russia, and even Russian companies, to be honest, do not know how exactly to comply with these new rules. So what are these new rules about? First of all, operator of personal data, for example, employer, must obtain a separate consent for data dissemination. So if you publish, for example, your employees' data on the website, there should be a separate consent to that. And the law specifically states that this consent should be separate, like not in the same consent, which is a little bit weird, but still, there should be a separate consent for this data dissemination. Data subject can set restrictions on the subsequent use of the data. More than that, there should be the special section in this consent with those restrictions. If there are no restrictions, it should be explicitly stated that data subject states, I have no restrictions on the subsequent use of the data. So it's not specified what kind of restrictions it could be, but any restrictions, we presume that, for example, data subject is okay with publishing his data on the website, but he's not okay with analysis of this data for scoring purposes, for example. So these kind of things. Then the next interesting part, that data operator or controller is obliged to publish information about the processing conditions, so about those restrictions that are set by that data subject. This obligation of operator will be enforced from 1st of July 2021, but companies are already wondering how exactly they are going to publish this information. Should it be published just, you know, in the same place where the data is published itself, or there should be some, you know, the sign I, like information, and there will be information popping up that this data cannot be used for this, and for that, or how else? Unfortunately, we don't have any clarifications so far, but we are really looking forward for them. And we hope that by 1st of July, at least, we will know how operators should do that. And also, the law states that data operators or data controllers collecting personal data from open sources must have legal grounds for processing personal data from such open sources. Meaning that if there is a data leakage, for example, or data just got into internet and you found it, it doesn't mean that you can use it just like that. You should have a legal ground. And in Russia, such legal ground as, for example, legitimate interest is not very popular and not very reliable, as opposed to GDPR in the EU, for example. So it's not that easy to say, oh, I processed this data just because I wanted to and I needed this for my business. And there is some balancing test, whatever. No, we don't have this. So it's quite risky to rely on legitimate interest, and other legal grounds such as consent or agreement or something like this. It will be difficult in case data is just on the internet. So we are still waiting for clarifications. We are still waiting for the form of consent that our regulator should approve. We only have a draft law on this, which is a bit confusing, and we do not really want to talk about this unless it's enforced, you know, because there are more questions than answers to this form of consent. But we'll see how it goes. And in case your business is involved in publishing of data in any sense, it can be employees, and can be clients, and can be some ads, whatever. So you should be really aware of this new rule and should keep an eye on development of this legislation and practice in this field, because it's still new, but everyone is already wondering how exactly it should be complied with. So yeah, this is about some great recent news from Russia. And we are now moving to a more classic topic, but still very, very important. We'll talk about privacy notice and privacy policy.
Yes, thank you very much. Yep. So moving forward to growth, obligations and requirements that should be met by data controllers. I don't think we will say something surprising to you right now, but Russian law, similarly to a lot of laws, privacy laws across the globe, require data controller to publish a privacy notice on its website or in the application. So privacy notice should be a document describing to users, to data subjects, what data is collected, for what purpose it is collected, how it is processed, is it transferred or not, etc. So generally, it is a document that should just explain and make it understandable for the data subject how his or her personal data is processed. But in addition to this privacy notice, it's also advisable to have privacy policy, being an internal document inside the organization, which will clarify to employees and other involved contractors how personal data should be processed inside. This is especially important in this case because we're speaking about health data being sensitive information and having more traction from the regulator and more even like moral and legal obligations of data controller to keep it confidential. So in this privacy policy, it is also advisable to establish the rights of access to the personal data so that each employee could understand what data can be accessed and not, and in order to ensure that this is complied with on IT structure, in IT infrastructure, it should be properly established who can access which folders, which data, etc. And the next requirement, which has been discussed a lot and still remains one of the hot topics under Russian privacy law, is the localization rules. So maybe a lot of you have heard about this, but just as a short reminder, localization rules require initial recording, storing, and updating of personal data in the Russian database. Further cross-border transfer is allowed. So let's just look on the slide, the standard route how data flow is going on. So me as a user can type in some of my personal data into my mobile application, for instance, regarding my health, regarding my personality, and so on and so forth. So from this application, data should be initially recorded and stored in some server located in Russia. After that, it could be transferred abroad, transferred to the cloud, or to any other IT infrastructure that is established by the data controller. And it's important to know that the same process, the same route should apply for update or any modification or change of personal data. So it's exactly the same. If I change anything, for instance, my phone number in the application, it should be initially recorded in the Russian database, and only after that updated, transferred to the foreign database. And during the existence of these localization rules, it was always a question whether mirror databases are allowed, meaning that if I type in certain information about me in my mobile application, is it admissible to simultaneously transfer it to the Russian database and to the foreign one? And the regulator has clarified that no, it is not compliant, because in this case, Russian database cannot be treated as a primary one, and this means that from the legal standpoint, the requirement is not observed. Talking about sanctions for the violation of the localization rules, the fines, a little bit more than 1 year ago, the fines have been significantly increased, and right now it is a fine from 11,000 to 67,000 euro for the first violation, and in case the regulator reveals another repeated violation, the fine can be up to 134,000 euro. For the Russian reality, these fines are pretty harsh, because usually we have much, let's say, funny amounts of fines, especially for big businesses. And another sanction is potential blockage of the website or an application through the court proceeding if the regulator finds that this website or application collects and processes personal data of Russian citizens without due observance of the localization rules. And of course, important thing with the localization rules is that extraterritorial principle is applicable to it. This means that if foreign company has some Russia-oriented activity, this foreign company shall also be compliant with the localization rules. By Russia-oriented activity, it is understood any activity that explicitly cover Russian market under business strategy. So, for instance, if you have a health application that is available for Russian users via app stores. And this application is also provided in Russian language. Despite that you could be a foreign entity, you should observe localization rules. And especially for this, the blockage option has been introduced by the regulator, by the legislator, and it is actually enforced. So we have pretty famous case of LinkedIn, which is officially inaccessible in Russia since 2016. So we don't have LinkedIn in the official Russian version of Apple Store, and we also cannot connect to it through the browser. And the next logical topic after the localization is the cross-border transfer. So cross-border transfer requirement depends firstly on the country of recipient of personal data. So if recipient is located in so-called adequate countries, meaning country providing for adequate measures of personal data protection, then the transfer can be conducted on general grounds allowed under the Russian law. So basically, there is no difference whether you transfer personal data inside Russia to another company or to adequate country. By adequate countries, the following jurisdictions are included: all parties to the Strasbourg Convention, and so this basically means almost all countries located in the European Union. And also there is a specific list maintained by the Russian regulator, which also provide for certain countries which are considered adequate under Russian privacy law. For instance, the list includes Japan, Singapore, Canada, Mexico. And if you're willing to transfer data to non-adequate countries, meaning all other countries, so for instance, the United States, China, or India are considered as non-adequate countries from the privacy law perspective, then you have a limited number of legal grounds for doing so. From the commercial perspective, only two of them really apply. It's the written consent that we have already discussed in a lot of details, and performance of the contract with the data subject. And regarding the second ground among these two, we should know that the controller should be really able to prove that without such cross-border transfer, performance of the agreement cannot be possible. So you cannot justify any cross-border transfer just by the fact that you have a direct agreement with the user. And following cross-border transfer, it is important to understand whether there are any peculiarities and exemptions for intra-group transfers, because GDPR provides for certain lighter regulation for transfers inside the same group of companies. And unfortunately, under Russian law, companies of the same group are still treated as a third party. So effectively, this means that if you want to share personal data inside the group, so for instance, there are several subsidiaries operating and managing the same health platform in different countries, and you want to collect data from different countries and share it inside the group in order to understand how platform or application is operating in general, then you need to comply with all requirements applicable to such transfer, including consent, localization, cross-border requirements, and so on and so forth. So unfortunately, there are no exemptions from the rules. And also, a lot of jurisdictions and local privacy laws provide for the obligation to enter into the data transfer agreements between two controllers when they share personal data. So in Russia, there is no such obligation, and you can avoid concluding this agreement. However, as a best practice and in order to show your compliance and very proper treatment of personal data inside organization, we recommend doing so, because this increases your transparency and compliance level. Yep. So that's all about intragroup transfers. Yeah.
Yeah, moving on with transfer of data, sometimes companies, when they transfer data not only intragroup but to other parties, they decide to avoid dealing with personal data, as they might think, by depersonalization. So depersonalization of personal data is actually quite a gray area in the Russian legislation, and we need to point this out. So there is a term, dissemination of personal data, that means under the law actions that make it impossible without the use of additional information to determine that personal data relates to a specific data subject. But in this wording, there are several questions arising. So if it's impossible to determine this personal data subject, you need to prove that it's actually impossible without use of additional information to do so. And in practice, it's not always easy to actually depersonalize the personal data. Also, we have another provision in the law that says that one of the grounds for processing personal data is processing of depersonalized data for statistical or other scientific purposes. And this ground is very helpful for some statistics, for example, for marketing purpose. It should be helpful, but in practice, sometimes we face questions on whether data is actually depersonalized and thus can be processed without consent or other legal ground. Unfortunately, there are no additional explanations, requirements from our regulator, except for government agencies and state bodies, which have some requirements. Sometimes the regulator said that these requirements can be applied to legal entities, but officially it's not so. And unfortunately, there is no practice or case law about depersonalization in Russia. Of course, we look at GDPR and we see that there are such great things like pseudonymization of data or anonymization of data. And we thought that maybe this could be a trend for Russia, and probably we could expect introduction of these terms into the Russian legislation, and probably this depersonalization of personal data is closer to pseudonymization according to the GDPR. But there is no answer, unfortunately, and as we see the legislative initiatives right now, they are not very pro GDPR approach, I would say. Unfortunately, we cannot expect right now that we will have this kind of terms, and therefore more clarity about how we can work with depersonalized personal data. At the same time, the legislator seems to be actively wanting to introduce additional boundaries and additional requirements to introduce, for example, special consent for depersonalization of personal data, which is a little bit confusing because the depersonalization is aimed at actually avoiding working with personal data. Why do you need the special consent for that? So there are many questions about depersonalization. The process is ongoing, and we want to warn everyone who is relying on depersonalization in Russia that it should be done really carefully, and there should be like a clear explanation inside the organization how it is done, for what purposes, and of course you should have a closer look at the legislative initiatives that right now are developed. Recently, we had a new piece of legislation about health data and AI, and it involves depersonalization. So as you may know, in 2020, we got a new initiative called Moscow Regulatory Sandbox, aimed at development and introduction of AI in several fields, including pharmaceuticals. And there is a new basis for processing of health data that was introduced into the law on personal data, namely processing for the purposes provided by this law on AI and Moscow regulatory sandbox. Purposes of this law are quite broad, so it's not 100% clear what's exactly there, but maybe it's a good thing. But then we got additional provisions saying that the personalized personal data cannot be transferred to non-participants of this experimental regime. So you see there are additional boundaries. Yes, you can process them without any other legal grounds, but you cannot transfer them to non-participants. And what we like the most, this data must be stored within Moscow, not Russia in general, like Vlad said about the localization requirement, but within Moscow. So this is a very restrictive piece of law, but hopefully it will help in some case to those participants of this regulatory sandbox that who are working in the health care sector and who will be using this kind of data. Talking about news, and we are reaching the end of our presentation, we need to talk about the increased fines, and I give the floor to Vlad because it's quite important.
Yes, so some very fresh news about further developments in Russian legislation in the sphere of personal data, that in actually 8 days, the new fines will be introduced in the code of administrative offenses. So basically, the fines are increased exactly, they have been doubled. So some of the examples, you can see them on the screen. So the first one is, for instance, processing personal data without proper legal ground, or breach of the purpose limitation principle. These violations could lead to the fine up to 1,150 euro. Processing failure to obtain written consent, if it is required under the law, can lead to the fine of up to 1,700 euro. And finally, non-publication of the policy on the website or in the application. So this obligation we've been speaking about earlier can lead to the fine in the amount of up to euro 700. We know that this doesn't sound really scary, these fines, but maybe in order to motivate companies to be compliant, the legislator has also introduced more increased fines in case of repeated violations. So, for instance, if a company within 1 year from the day when they should have paid fine for the first violation have committed this violation again, then it should pay the fine in the increased amount. So basically, it's just like 3 times figures you see right now on the screen for the respective violations. So while these fines cannot be considered as very harsh comparing to the GDPR fines and current practice that we are interestingly read from the practice, we still should know that this confirms the recent tendency regarding more significant control over personal data processing and personal data protection, and that sanctions will be evolved, sanctions will be increased from year to year. So this is just additional thing to think about how data is processed right now, whether something is done wrong, whether something should be justified in order to be compliant with all requirements. Yep, and to sum up, we would like to just quickly remind you about what have been discussed so far.
Yes, as a resume of our webinar, we have prepared a so-called checklist for digital health and personal data in Russia. So first of all, you need to remember that health data in Russia can be processed only based on written consent. Collecting of health data of employees shall be limited, especially when we're talking about, for example, vaccination that does not affect the performance of job functions. Also, consent for advertising must be explicit, voluntary, and separate from everything else. There are new requirements on processing of publicly available data, and they should be met. How, we will see. Privacy policy must be on the website or in the app, and preferably to have a privacy policy, internal, more extensive one, explaining how data is processed. Companies should comply with the localization and cross-border transfer requirements, even if it is an intra-group data exchange. We need to remind you once again that depersonalization of personal data is still a gray area, and it's still developing, and we are expecting more legislation in this field coming soon. And there is a trend in Russia on increase of fines. They are not so scary as the fines in GDPR yet, but we are on the way. And those fines fines are not the biggest problem, you know. Being on the radar of the regulator is even less comfortable for the companies here. So this is everything we wanted to tell you during our presentation. Thank you very much for your attention. And I see that we have some questions in the chat already, so we'll now move to the questions section. And I think I will stop sharing the screen so that you could see us better. Okay, I stopped, right? Vlad, please confirm. It's not shared.
Yeah. You start sharing the screen.
Cool.
Yeah.
Great. So let's move to the chat now, and we'll see what questions we have. Okay, there are quite a few of them, which is great. Our organizers will help us, and they will post the questions in the chat section so that everyone can read them, because sometimes questions are quite lengthy, so that you could read them as well. Okay, shall we start with the first one? I see it's about employees, so Vlad, do you want to take it?
So the question is about what employees collecting data about sickness absence of employees. This is a health data. We don't usually use consent under GDPR in EU as the basis for that. Yeah, indeed, like it's a general difference between the GDPR and Russian law, that under GDPR, usually data controllers are trying to avoid collecting consent. So consent should be a last resort in order to justify data processing, and it is advised to find any other justification. In Russia, currently, the practice is opposite, because consent is easily to be collected, especially in case of employees. And if you are checked by the regulator, consent is something that will be a 100% proof for them. There will be no questions. There will be no request for additional justification, what is legitimate interest, why it is applicable in this case, and so on and so forth. And in addition to that, in Russia, we don't have the same rule that the balance of like bargaining positions should be checked whether at the moment of consent. So, for instance, employee is deemed is not deemed dependent on employer status quo, and that's why such consents don't seem to be imbalanced. So that's why, yeah, if you want to collect information regarding sickness absence data, this depends on what information you want to collect. If this is simply a confirmation that from the doctor that this person has been indeed sick and was not able to be present in the office, that's fine, because you don't collect any particular health data. However, if you want to collect health data, I mean, knowing exactly the reason what happened to a person, like whether it was broken leg, broken arm, something else, then you should need additional justification, because you will collect some additional health data about employees. And this is because the employee has already been back to office. You don't need right now this to think to use the justification that you are assessing fitness to a particular job function.
Okay, I see that the next question also relates to employees. I will read it and then Vlad, I think, will share the answer. An employee uploads a photo to the internet. The server is outside Russian Federation. The photo is used on all internal platforms, Outlook, SAP, Teams, and is often used in presentation, e.g. for demonstrating the organizational structure. The employee does not sign a consent. The photo is immediately sent to a server outside Russian Federation. Does this qualify as a violation? And if so, what steps should the employer take to fix the violation? If consent is required, can we use simple consent without specifying on what platforms the photo will be used? Can we use general wording that the photo can be used for internal presentation materials? That's what I was talking about when I said that some questions can be lengthy. So you can read it in the chat if you didn't get it from my reading. Vlad, do you want to share your thought about that?
Yeah, sure. Yes, so I see several. So the question here is mostly about consent, not about the localization rules. But just because I also see an issue here with the localization rules. So before uploading this photo to some platforms that you use internally in the company, like Outlook, Teams, we'll all use them, right? You just need to ensure that this photo has been initially stored somewhere in Russia, so that Outlook, so Office 365 is a secondary database in respect of this portion of personal data. And as regards consent, whether there should be a simple consent which states that the photo will be used like on some platforms. We saw both approaches. Sometimes companies tend to use general wording in order to cover as much processes as possible. This is one of the options, but it entails the risk that consent could be qualified as non-informed, meaning that, for instance, me as an employee granting consent for publication of my photo, I cannot properly understand where it will be published. So here is the risk that the consent could be qualified improper. So we usually recommend, to the extent possible, indicate all sources where a photo will be published, where personal data will be used. So for instance, SAP for certain purposes, in Teams, just in order to reflect your image to other addresses with whom you communicate, etc. So as long as you can provide more detailed and more informative consent, that's the better, because this will help you to make a proper consent, which will be easier to justify in case of any inspection. And also you can combine both options, so you can make a pretty long list about all sources that you use, and at the same time make it a little bit quasi-open, so make a reference to other platforms that are used by the company.
Yeah, I think it's pretty clear. And we were not asked about whether photo is a biometric personal data. The answer is not always, but can be. So, but in your case, as you described it, it's not, I think. So it's the simple consent will suffice. Okay, the next question. Can the sender's address of an incoming email be considered a simple electronic signature, provided the sender logs into the corporate network with a combination of login and password and sends the email from its corporate mailbox?
I guess it's my question again. And
okay.
yes, My answer would be yes. This can be qualified as a simple e-signature, but the only condition should be that you and data subject should previously enter into some agreement which says that all documents that is sent from this email should be considered as signed by the electronic signature being equal to the real signature. So if you have a proper contract in place confirming that this is how we should sign consents, agreements, other documents between us, that should be fine. Yeah, and as far as I remember, on the website Q&A section of some authority, I think it was Minkomsvязь, so-called Minkomsvязь, the ministry in charge for the clarification in the sphere of personal data, they have replied to this question as well. And the question was almost the same. So we even have confirmation from the authority in charge that such option is possible.
Yeah, hopefully they did not delete this clarification from the website.
That's correct.
Okay, let's move on because we have quite a few questions yet. So does the new law about the data permitted for dissemination apply to the intranet? Or is the intranet classified as providing access to a limited number of people regardless of the number? That's a very good question. Thank you very much. It's one of the topics that are widely discussed right now because the law says that these new rules apply to dissemination of data for unlimited number of people. And, you know, from this, I mean, if you make a parallel with, for example, advertising law, where the same criterion applies with unlimited unlimited circle of people, then most likely intranet should be considered as a limited number of people because you can understand what amount of people and who exactly will be on this internet because these will be your employees, for example. We hope that this understanding will be applied by the regulator as well, although of course there are some, you know, opinions that they may say that you don't know who will be on this internet tomorrow, so potentially it's a limited number of people. But I really don't want to believe into this approach. I hope that the internet will still be a limited space, let's say. Okay, next question. So if I got the personal data from someone and do not have a consent from the relevant person, I cannot use it, correct? It's a question, correct? Well, thank you for the question, but it's my favorite answer, it depends. Because you could get this personal data from your counterparty under the agreement, and there can be certain provisions in this agreement about personal data, for example, establishing obligation of this party to ensure there are relevant legal grounds, for example, consents obtained from the particular persons whose personal data is transferred. Normally, it's done like this. But if you don't have something like this, there is no agreement between you and someone who got your personal data, I would be really, well, careful in this situation because you need to ensure that you have a legal ground for processing such data. If you don't have it, then you're in trouble. Yeah, but of course, more details are needed. Every case should be analyzed independently.
Maybe this is relates to the this new category of personal data like disseminated, and for instance, if somebody what would that, yeah, it depends on what do you mean by transfer, but if you use personal data that has been disseminated by some other controller and you want to use this information, you need to check with this controller whether some restrictions have been imposed by the data subjects when consenting to the dissemination. Yeah, it's a little bit complicated procedures right now.
Yeah, or this controller probably should publish this information about restrictions, and if he doesn't, then should probably there are no restrictions. But it's not for sure, because we are not sure that everyone complies with this new legislation. So yeah, there are many aspects there. Okay, the next one. How do you evaluate the purpose of data processing about adverse events information as the protection of life, health, etc. of the subject of other persons? Of it is impossible to obtain consent. In fact, most of AEs is obtained from HCPs, so it's impossible for the pharmaceutical company to obtain consent from the patient. I see there is a specific issue behind this question, but we are not given all the details, which is complicated. So you mean this ground that you can process data for protection of life, health, etc. subject when it's impossible to obtain the consent of this data subject? And the question is how to evaluate the purpose and to make sure that you actually process it for this purpose, for protection of life, health, and etc. Vlad, do you have the same understanding of this question?
Yeah. I think actually my understanding is that it would be hard to think that because this ground is applicable when there is some imminent and immediate threat to health or life, and like you don't care about this during like when you're trying to help people. And when we are talking about collecting information about adverse events, well, I think it's like more a little bit routine process, which is not associated with immediate threat to health or life of a patient. It's more about collecting information about adverse events. So my preliminary response would be that this ground will not be applicable in this case.
Yeah, maybe if we think about some applications that are designed for helping people in these emergency situations. But again, if person is using this app, most likely there is some kind of consent. So yeah, it's hard to imagine when exactly this ground can be used. Maybe in some particular issue with all the details, it could be easier to analyze. Okay, the next question, I see it's in Russian, but I think we can translate it. Please clarify in which provision of the law it is said that privacy policy is the mandatory document, and about the policy, it's all clear. I think I can clarify, because when we refer to privacy policy in Russian and in English, there can be some discrepancies. So there is indeed the obligation in the law to publish the policy on processing of personal data, which we can refer to as a privacy policy or privacy notice in the terms of GDPR, for example. And regarding the policy that should be established internally, well, there is no direct obligation and in the law, but the law states that wherever you collect this data, there should be a policy. So if you collect data from your employees, there should be internal policy. And also, of course, it's almost the first thing that the regulator will ask you about, to see what processes you have with the data, how it is processed, where it goes, what the data flows. Yeah, so
yeah, if we're speaking about particular provision, it's either 18.1, Article 18.1 or 19. So there should be a list of measures among which you can find the one of the obligations to adopt such policy.
Yeah. Okay, next one. Do I understand correctly that after the entry into force of this new legislation about the disseminated data, the use of systems that collect data about HCPs on the internet, aggregate data into its databases and provide such information for pharmaceutical companies, for communications with doctors, monitoring visits to HCPs, etc., violate the requirement existing from March 1st? Accordingly, pharmaceutical companies using such software with aforesaid databases also violate personal data legislation. Okay, so there are systems that collect data on internet, aggregate data, and provide to pharmaceutical companies. I'm not sure that I see here the dissemination of data for the unlimited scope of people, you know. So this looks more like a transfer of data, and this is one more important point that we should probably touch upon, that this law says about dissemination, publishing, whatever it can be translated into English, sorry, but it doesn't say about transfer of data, unless it's a transfer to everyone, unlimited scope of people. So here, in your case, it looks more like a transfer rather than dissemination. So from what I see, I wouldn't say that this law would be applicable. Vlad, do you have anything to say?
Yeah.
Okay.
Yeah, the next one is in Russian. Yeah, and I guess it refers to me, sir. It is like we're asked about the clarification if it is admissible to, if the personal data collected in Russia goes through the integration system abroad and then goes back to Russia. In this integration system, they are not recorded. They're not recorded. So the question is whether this is compliant with the data localization rules, I guess. And yes, we have considered such option in practice. When data is collected in Russia, then there is some foreign system hosted on a foreign server, which has some technical function about where the data should go, whether it should go to a foreign server or whether it should go to the Russian server. So use simply of this technical solution in order to further record and store personal data in Russia should be deemed compliant, because in this case, the literal interpretation of the law is observed. So the literal interpretation, then when collecting personal data, it should be recorded, stored, etc. in the Russian server. So this means that this is all the process of collection. When data is collected, goes through this integration system and then recorded to the Russian database. So from your description, I would say that this is a compliant option.
Okay, great. Going on. If a data controller obtains a separate consent for the personal data dissemination without restrictions and limitations and publishes such data according to this consent, are other data controllers allowed to process such publicly available data based on the consent its copy obtained by the initial data controller? Yeah, so basically, we believe that this is the point, that if it's published and there are no restrictions, and this information that there are no restrictions is also published somewhere, available somewhere. So yes, other controllers, they can process this data because there are no restrictions and limitations. The other question will be how to make sure, unless it's explicitly stated on the same page, for example, that there are no restrictions and limitations, how can the data controller actually be sure that there are no such things? So I think the answer to your question is yes, they should be allowed to process such publicly available data, but we'll see how it develops, and maybe it should be done carefully, at least at the first stages of application of this new law. Okay, next one.
Yeah, next one. It's about the localization again. So the question refers to whether the use of, for instance, Excel file with personal data located in Russia can be treated as primary database, and after that, this data transferred abroad. So Russia law defines database as a structured composition of data that could be searched with computer tools. So basically, yes, Excel falls under this definition. And if you store certain personal data on your local computer, on local laptop in Russia, and then and you officially recognize this as the primary database, and only after that transfer information from this Excel file abroad, this is a compliant option as well.
Yeah, it was one of the first options and favorite options when the localization requirement got introduced, and Excel files were the lifesavers for the companies, and they still can be. There is no, I don't know, clarification or anything.
Yeah, unless if it's like some stable composition of data, some stable set of data, which is like simply need to be stored here and there, that's like the very simple solution. But if this data is like processed on day-to-day basis, Excel files, what tables are not very viable solutions.
Yeah. Okay, the next question. The company is using a cloud solution, software as a service, that is developed by another company. Employees of the developer have access to the information of their users for the purpose of maintaining this cloud service. Should the company indicate in consents such a developer as a third party to whom the data is transferred? That's a good thing. Well, as you know, there is a difference between transfer and processing assignment. So under the law, the consent should contain the information about those third parties that process data, so-called processors, right? In this case, I'm not sure they're the processing party, because it's basically the instrument there, although it really depends on the type of data and the type of operations that are conducted with this cloud solution. But if it's not a processing, like assigning the processing and just a transfer of data to this technical solution, I mean, the best practice, I think, and Vlad, add please if you know other solutions, but the best practice, as I know, is to mention, as Vlad actually said previously, to mention all the systems in which data is processed, and to indicate that this and that systems are used and software is used for processing of data. I think this would be very sufficient for employees, that they know that these systems are used, and maybe it's not that important to mention that this and that operator of this solution is involved. Vlad, I know, what do you think?
Yes, agree. And in addition to the whether this relation should be treated as controller processor, it indeed mostly depends on what operations are done by the developer, meaning whether there is indeed any instruction of the data controller to the data processor to process data on its behalf. So if it's like simple possibility of access, then I doubt that this should be treated as instruction to process personal data.
Yeah, it's not like outsourcing the data processing, it's more like an instrument that you use in your company. Okay. Is the regulator imposing many fines in practice? Are they active in imposing fines? You know, it's really a question of assessment of activity. It's not, they're not so active as many EU data protection authorities. What do you think?
Yeah, like according to the statistic, actually, if you simply divide like the whole amount of fines that have been collected during the year to the number of entities that have been fined, then like the general amount is something around, I don't know, 500 euro per company. So it's not very harsh. And however, as I said, there is a tendency about like further enforcement, and we believe that increase of fines connected as one of the reasons it is connected in order to improve statistics of the data protection authority regarding collection of fines and the final figure. And as regards these more serious fines for the localization rules, we cannot say that they are like very active in imposing this, but we know like from public sources, you know, at least 2 cases, it's Facebook and Twitter, who were fined with 4 million rubles for in-compliance with the localization rules. It is around, I would say, 45,000 euro. So for Russia, it's pretty important fines. So we cannot say that they are like very active, and it's like if you have a violation right now, like 100% in 1 year, you will receive a fine for this. No, it doesn't work like this right now, but still, you never know if there is any complaint about you submitted to the data protection authority, if they just find some information about potential violation in the internet. So there could be a lot of reasons why inspection could come, and of course our advice as a lawyer always is to be as compliant as possible.
Yeah. Okay. Can privacy policy be not a separate document but included into terms and conditions? Well, of course, you know that the best practice is to make those documents separate, and the law says that there should be a policy published. So, of course, it will be more easy to prove that you comply with this obligation when you have this privacy policy separately. I mean, you can make a section called privacy policy in terms and conditions. I think I haven't heard of anything like precluding you from doing this. The most important thing is that it should be there. It should be established and published. Vlad, what do you think?
Yeah, same. I haven't heard about any prohibitions in doing so. So yeah, formally the obligation is performed, so there should be no issue. Consent shouldn't be, it's not advisable to put consent inside the terms of conditions, but for privacy policy, it seems to be fine.
Okay, if the data is saved in the app that is used by other affiliates from different countries of a group of companies, and employees from affiliates have access to all data on such app, does it mean that the data is being transferred to them? Yes, the brief answer is access is deemed to be transferred. So if there is access from the foreign land, yes, it's considered as transfer. Yeah. Oh, the next question is great. What you can recommend for using Office 365 to be compliant with the localization rules? Well, I will not say it like 100%, but I think I heard, and I think I even saw something about this. Anyway, that Microsoft is actually one of the companies that provide local decisions for Russia in order to comply with the localization rules. So you may consider checking this, whether you're using this solution from Microsoft. So yeah, this would be my recommendation, I think.
Yeah, it's like the right solutions that provide like official distributors that provide compliant solutions. And given that in a lot of cases, Office 365 is purchased on intragroup level. So for instance, it's purchased by the global company and spread over all subsidiaries. Sometimes it's not very viable to find such to purchase separately a local solution. So here in terms of localization, actually it should be considered like product by product. So you should think about Cortana, like my analytics tool, Teams, and all other features. But let's just like focus on Outlook. So Outlook is actually an email service, and you can receive a lot of emails containing personal data. So one of the options is to consider Outlook as a tool which helps you to collect personal data. And once you to make the same internal policy saying that Outlook is emailing service which is used for inter alia collection of personal data, and you should oblige all employees to record and store to move email containing personal data to some local folder once it is received. So if you have this procedure in place, this can help you to justify that you're literally in line with the law, saying that when collecting personal data, it should be ensured that it is recorded in the Russian database. So if you try to treat Outlook as such collection basis tool and ensure further initial recording in the Russian database, this could be a solution. So this should be covered by a lot of papers internally. And unfortunately, I should make this disclaimer. This is based on like interpretation of the law, but has never been confirmed by either court or data protection authority. So it cannot be totally excluded that such collection games, play with collection could be not found incompliant in the end. But there are options and there are things to think about when you try and find a compliant solution. Yeah.
Yes. Okay, then let's move to the next one. I'm just checking where it is. Okay. If a Russian citizen attends some online training provided by some foreign company abroad, and the video of this training is published on a foreign website of the provider, shall the provider collect this new consent beforehand? Thank you. Very nice question. One more topic that should be, considered when we talk about this new piece of legislation. I'm just thinking whether this foreign company will be covered by the personal data legislation in Russia. Maybe we should start from there. Maybe they will be not. For example, if there is just a foreign event and foreign company that does not target their business on the Russian market, and just the employee wanted to go there and participate. But otherwise, if we exchange foreign company to Russian company and the video of the training is actually published, so the data is actually out there, well, probably this will be the case. Yeah, probably this new consent will be required because strictly speaking, this is the dissemination of personal data. Interesting.
Yeah, it depends whether it will be indeed personal. So if this will be simply an image of one of participants of the training, and you cannot really identify this person. Yeah. So it depends. But if you have like name, company, and image, definitely this personal data, and most probably consent would be required.
Yeah. Don't publish recordings of all the trainings. That will be a recommendation. Okay, next question. Corporate email addresses and corporate mobile phones are published on the website. Yes. Do you agree that this new consent is not required, as we can consider corporate email as not being personal data? Oh, I have bad news for you, I think, because normally this information will be considered personal data, because, of course, you mentioned Ivan Ivanov ad, but still after ad there will be a company name, so we will limit the scope of Ivan Ivanovs to those who work in this company, and most likely there are not more than 2 or 3 of them working in this company, so you can understand who this person is. So most likely it's personal data. If you think about my address, it's irina.shurmina at cmslegal.ru, so it's clear who it is, and it's definitely personal data, and mobile phone in connection with this data will for sure be a personal data. So publishing those data on website will require this new consent. We are like almost 100% sure about this. Should the previous agreement on using electronic documents be a separate agreement, or can it be implemented as a specific clause in the main service agreement between the parties?
Yeah, I think it's about electronic signature again, yeah, and the contract between company and user allowing use of e-signature. Here it's like general civil law rules apply, and this could be structured in a way that there is a public offer on the website, and if you, for instance, register your own account, you accept this public offer. And if this public offer states explicitly what is deemed like simple electronic signature and how it can be used in relations between parties, then yes, this agreement will be deemed concluded, and further on documents can be signed with the simple e-signature via personal account.
Okay, I see the next question. What law says that privacy policy should be on the website? But I think we already answered that it's a personal data law. It's Article 18.1. And we have several questions left, and I think we need to, do it faster to finish our webinar. If a Russian citizen attends, okay, we saw it, sorry, it's doubling. Can an employee in a hierarchy employment relationship give voluntary consent? What happens with data processing by the employer if the employee withdraws his consent? Okay, but consent when, yeah, sorry, Vlad, go ahead.
Okay, yeah. So we understand, like, you're concerned that in employment usually the relations are pretty imbalanced as such, and that's why GDPR provides for this rule that employee is assumed to be dependent and in hierarchic relations. But currently we don't have any similar practice in Russia. A couple of years ago, I think around like 3 or 4 years ago, there was a bill saying that it is prohibited to ask for the consent in similar situations when depending on consent, you condition performance of the agreement, including employment agreement. However, this bill has never passed, and in practice right now, consents still deemed to be voluntary in relations between employee and employer. And as regards revocation of the consent, if it is revoked, then the employer still able to process personal data to the extent it is justified by other legal grounds. For instance, for performance of employment agreement, for performance for group employment agreement, or for instance in order to perform some obligation imposed by the law. So yeah, basically we understand that in some cases revocation of consent can factually lead to inability to perform job functions. So I don't know, without consent you cannot use Outlook, so without Outlook you cannot send and read emails, and this could potentially lead to some disciplinary action under labor code. So yeah, if we speak strictly under personal data law, then the processing should be restricted only to the extent allowed by other legal grounds.
Yeah, good that we have not only consent but other legal grounds in place. Employers, I think, a bit on the safe side here. Okay, I see the comment. Privacy policy of Microsoft Cloud 365 says they have access to all data processed via their solutions. They also provide broad purposes of using such data. Should the company which uses Office 365 specify all such purposes in its consents as well? Well, I think the company should determine the purposes, first of all, based on its operations and its purposes. When it specifies that it uses Office 365, the company can include some additional information about how exactly this data is processed in this system. I'm not sure that you need to include all information, like from the privacy policy of Microsoft in the consent, but I need to be honest with you, I didn't look on their privacy policy for already quite some time. I remember it was quite extensive, but I'm not sure that you need to include all information in the consent. Vlad, what do you think?
Yeah, I agree with you.
Yeah.
Yeah,
Okay. I think we have the last question. If you still have questions, you can send us like a plus and we'll see that you are still working on the question. But if not, we will finish the webinar soon. So we have our next question. Can a company collect personal data of a patient during the phone call in the framework of hotline to help people to know how to use specific medicine? Is it okay that consent is given orally during the telephone call? That's a great question. Well, if we are talking about the patient data, like meaning the health data, then this oral consent over the phone call, I mean, it can be risky because still health data must be processed based on the written consent. So here we have some discrepancies with the development of telemedicine, for example, right now when people don't come to the clinic, they just use the phone or the internet to contact with the doctor. So yeah, I think it can be quite risky, but probably if this company is like it's not the first contact with this patient, then it could have collected this consent beforehand. What do you think, Vlad?
Yeah, I would also, for me, it also depends on how you further use these personal data. So if this is limited, like for instance, me calling for the hotline and telling that, like, my name is Vladislav and I have some problem with my arm, what should I do with this specific medicine? And you just reply me like, you should use it as in following instruction, and this then my data is not recorded somehow, is not stored, nothing. So it was just like phone consultation, after which there is no further collection and use of my personal data. Then there is practically nothing to worry about. But if you wanted further to use this information, then somehow collection of consent should be ensured.
Yeah, this is a very important question, I think, for pharmaceutical companies who develop some medicine and they want to get feedback from the patients and they want to see. But I mean, we have some clients who had these issues and there were some solutions that either you do not collect, but you should collect this data, right? But there is maybe some some decisions on how to collect this consent from the patients, at least with all the risks beared in mind electronically. So yeah, this can be an issue for sure. I see that we don't have questions so far, and we are actually a bit out of our time that we said that we're going to spend. And thank you for everyone who is still here. We really appreciate that. Unless there are other questions, I think we are going to finish and wrap up our webinar. And we very much appreciate that you spent this time with us and you came. And thank you very much for all your questions. They are extremely interesting and very in-depth, and we hope that our answers could help you at least a little bit with all the limited information and time that we have. If you have any more questions, you know where to find us. You have our contacts, and you will have the recording of this webinar and the presentation sent over by our organizers soon. So please feel free to contact us if you have any issues, any questions. And we hope to see you on our next webinars. Stay tuned. If you are not subscribed to our newsletter, please do so that we can reach to you. There will be a separate consent for our newsletter for sure. And yeah, thank you very much. And be safe. And stay safe and healthy.
Have a good evening.
Yes.
And weekend. I meant weekend.
And weekend. Yes, it's Friday. Okay, thank you very much. Have a nice day, have a nice weekend, and see you next time. Bye-bye.